you. Well, I think we can then make a start. Well, good morning, ladies and gentlemen. Welcome to this next in the FTB series of webinars. The subject of the discussion this morning is Section 106 planning obligations and CIL, and the opportunity for both processes to be operated in a way that responds to the effects of the present crisis. I think it's fair to say that views may differ as to the likely medium and long-term effects on the development industry of the current crisis. Anecdotal evidence, however, does suggest that in the shorter term, the effect of the lockdown has been to suppress development activity and completions, in particular, of new homes. The economic effect of all this can't be predicted with any certainty at this stage, but the government seemed to be taking no chances. And I'm sure, as many of you are aware, on the 13th of May, the government issued guidance concerning CIL and Section 106 and gave what I think can properly be described as a clear instruction to local planning authorities and to collecting and charging authorities to exercise the powers and discretion available to them in a way that is flexible and responds pragmatically to the pressures confronted by the development industry. And it is how those flexibilities and that discretion can be exercised, which will be the main subject of the discussion this morning. Sarah Sackman is going to begin the discussion by talking about the processes for varying and indeed extinguishing Section 106 obligations, and in particular, the way in which the courts have approached the exercise of those powers as set out in the Town and Country Planning Act, and then examining the opportunities that those powers present. I'll then take over and address the issue about enforcement of 106 and certain other matters that may be of interest in terms of the long-term operation of Section 106 obligations in light of changed circumstances. And then I'll turn to CIL and discuss the various powers that are available to charging and collecting authorities to assist the development industry. You will see, as I'm sure many of you are very familiar with, the question and answer icon at the bottom of the screen. Please use that to post any questions or indeed comments or observations that you have, and we'll do our best to answer as many of them towards the end of this webinar, which we hope to complete on or only shortly after 11 o'clock. So without further ado, I'll hand over to Sarah for her discussion on Section 106, amendment and extinguishment.
Thanks very much, Douglas. I'm just pulling up the slides here. Thank you for that introduction. As Douglas said, my object this morning is to cover the statutory process for varying and discharging, renegotiating, if you like, Section 106 agreements, and to look at what scope there is for doing so and what practical approaches developers can take. As Douglas alluded to in his introduction, I think it probably is too early to understand precisely the impact of the pandemic on things such as viability. We know both anecdotally and in terms of the data that was published for April and now May, that the rate of property sales is down, that it appears that there has been a cooling in property prices. And so what knock-on effect that is like to have in terms of development remains to be seen. But as many of you advising developers or developers yourselves will know, cash flow is an issue, and we all want to avoid stalled schemes, and worse still, developers going out of business. And there are two aspects to that which are impacted by the operation of Section 106 planning obligations. The first, it seems to me, is the timing of payments, where you have agreements where contributions have all been negotiated and envisaged coming at the commencement of the development. if that coincides with the situation in which we're now in, that may present some problems for some developers. And so the question of timing, it's not about whether the developer may be good for the contribution, it's simply that right now is not a convenient time to have to pay it. And so the issue of whether that can be pushed back to later in the development process, closer to completion, is one aspect. And the second aspect, of course, is quantum, and where that bears in particular on questions of viability, where a Section 106 agreement has been made containing substantial affordable housing requirements. Yes, there we are, more evidence that the pandemic is having, it would appear, effects on house prices, but as I said, remains to be seen precisely what the implications will be. But clearly developers will want, if they can get it, some flexibility, or indeed the ability to modify obligations which they entered into in economically healthier times. And there is a precedent for this. We know that in the last recession, property industry and the Law Society itself lobbied hard for changes to Section 106, and we'll return to that, and whether that the legislative provisions that were made in the last recession, which effectively forced local authorities to renegotiate Section 106 agreements where they concerned affordable housing requirements, whether the government will choose to follow that blueprint once again. It hasn't yet done so, but it may be a useful place to look if we want to predict what the government is likely to do. But in terms of what the scope for modification or discharge of planning obligations looks like, the provisions are contained at Section 106A, and I set that out over the next couple of slides. And effectively what this provision provides is the ability for planning obligations to be renegotiated at any point where that's by agreement between the local planning authority and the developer. So where there's, if you like, a motivation to do so on both sides. Where there isn't agreement to voluntarily renegotiate Section 106 obligations, and that planning obligation is over 5 years old, then what this provision allows you to do is to apply for the local planning authority for the modification or discharge of those planning obligations in circumstances, and this is the critical test which we're going to focus on this morning, in circumstances where that it can be shown that that obligation no longer serves a useful purpose. And that's the threshold that a developer has to meet in order to justify the discharge of a planning obligation. And if you look at subsection 6c on the slide there, it provides that if the obligation continues to serve a useful purpose, but that purpose would be served equally well if the modifications sought in the application are approved, then it shall have effect subject to those modifications. So if in seeking to modify a planning obligation, you can show that it will continue to serve that useful purpose, then those modifications ought to be accepted. But otherwise, the onus is on the developer to substantiate that the obligation no longer serves a useful purpose before it is going to be able to persuade the local authority that it should be either modified or discharged altogether. And I think what's clear from the legislative provisions that we've just looked at, and I suppose really the theme of my remarks this morning, is going to be the extent to which the statutory framework as it stands places all the cards in the hands of the local authority. There's, as we'll see, is a wide discretion as to whether they want to accept the modifications that are being applied for. And within the 5-year period, after the original agreement is signed, the authorities are under no obligation to renegotiate with developers at all. So any negotiations that take place within that period are going to be down to the discretion and benevolence of the local authority. That having been said, the courts have made clear in a case called Batchelor, which we'll return to, Batchelor in North Dorset, that a refusal by a local planning authority to even consider the modification of a planning obligation within the 5-year period is amenable to judicial review. But I would suggest that that sort of challenge is going to be difficult to bring, given that given the way in which the provision under Section 106A is structured. And that 5-year period prescribed by Section 106A appears to have been chosen to go inside with the lifetime of an unimplemented planning permission, which makes it difficult for developers to escape liability for capital works or payments which are required prior to the commencement of development, unless, of course, the local planning authority is prepared to be flexible and agree to the modification of those. So turning then to the question of whether an obligation serves a useful purpose. That test is a very wide test, and what it poses is a high evidential burden which developers must meet before they are going to be able to achieve the modifications that they want to achieve. I make the point there in the second bullet on the slide that an application to modify an obligation is an all or nothing decision. And what I mean by that is that when you come to apply to modify your Section 106, it's not open to a local planning authority to accept some modifications and not others. They've got to deal with the application as it's presented in its entirety. Now, of course, if you get the feedback that some of these modifications are more acceptable than others, then of course a proactive local authority may invite a fresh application or an amended application. But that's something to be aware of when preparing an application. In common with a planning application, I suppose, having those pre-application discussions so that you can focus your requests on those modifications which are likely to find favour with the local authority seems to be something that would be worth doing. So from the local authority's perspective, putting oneself in their shoes, the 4 key questions, and these arise from and were explained and explored further in the Garden and Leisure Limited North Somerset case. The 4 key questions to focus on are: 1, what is the current obligation? What is the nature of the existing planning obligation in the Section 106 that's been previously agreed? 2, what purposes does that fulfill? 3, is it a useful purpose? Does it continue to be a useful purpose? And 4thly, would the obligation serve that purpose equally well if it had effect subject to the proposed modifications that are being put forward? Now, one of the questions that has come up and arisen in the discussions of that test in the case law is whether the obligation has to serve a planning purpose. In the Batchelor case, the High Court there accepted the agreed position of the parties that useful purpose in this context meant a useful planning purpose. However, that has been doubted in subsequent cases, and in particular, most recently, the Mansfield case, in which Mr. Justice Garnham expressed the view that a renegotiation of Section 106 planning obligation does not bring with it the full range of planning considerations as would arise in the context of an application for planning permission and the decision whether to grant or refuse that. He pointed out that the word planning doesn't appear in connection with useful purpose in the context of Section 106A, and that it would be wrong to read in the word planning into the statute. The question is simply whether the obligation continues to serve a useful purpose. And what's interesting is the way in which the cases have, and the courts have chosen to interpret useful purpose in a very broad way, pretty much encompassing, well, certainly planning purposes, but pretty much any useful purpose which the local authority, which relate to local authority functions and expenditure. And I pose the question there as to whether the distinction between useful purpose and planning purpose is one of significance. Clearly there's some debate between the cases. When the Section 106 obligation is entered into in the first place, it has to serve a planning purpose. So the original purpose will clearly relate to the development in question and rendering that acceptable, and there has to be an interrelationship there. But what the Mansfield judgment appears to establish is that when in the context of seeking to modify those planning obligations, one is not restricted to considering purposes which relate directly to the underlying development or the mitigation of some of its planning impacts. Indeed, as I go on to note in the next slide, the purpose now served by an obligation may be a different one from that which was intended to be served when the planning obligation was entered into, yet provided it continues to serve a useful purpose in the local authority's reasonable judgment, then there's no justification for discharging or modifying that obligation. And if we look at the cases which deal with it, the facts in those cases offer, I think, a good illustration of just how high the test, if you like, that developers have to meet, and just how wide the discretion that local authorities have is. So, for example, in the Renaissance case, which in common with Mansfield said that useful purpose just means useful purpose, doesn't need to be a useful planning purpose, the Section 106 obligation in question, in which the developer was seeking to discharge in that case, related to an obligation for the making of a contribution towards infrastructure costs, and particularly education costs, which had been included by reference to the local authority's supplementary planning guidance. Now, by the time the application was being made to modify and discharge that obligation, that supplementary planning guidance had fallen away. It had been replaced by new guidance, which was far less onerous in terms of the levels of contribution it was seeking. And what the court held in the Renaissance case is that the original obligation, as negotiated, didn't become either unlawful or unenforceable due to the subsequent changes in the guidance. It was sufficient that obligation, which required the developer to make a contribution to education costs, continue to benefit people in the local area, regardless of whether it went to specific types of education or not, provided it continued to benefit people in the local area. That was sufficient to show that it continued to serve a useful purpose, and consequently that there was no basis for modifying that obligation. Similarly, in the Mansfield case, which, as I set out on the slide, makes clear that that a useful purpose doesn't need to be directly related to the underlying development or its mitigation. In that case, the planning obligation that had been entered into was for the payment of a sum of money towards the provision of a highway in connection with an application for residential development. The land was not in the end developed, and the developer sought to discharge the obligation, requiring the payment of the balance of the sums due. In the meantime, it should be said that the local authority had paid and indeed built out the highway, which would release that particular site allocation. On appeal, the inspector agreed that the obligation should be discharged, essentially because he found that it was unnecessary to allow the development to be acceptable for that obligation to be adhered to, because the road had now been in place for a substantial period of time, and therefore he concluded that the obligation no longer continued to serve a useful purpose. However, the High Court noted that whilst it was right to say that the payment of money would not now be directly related to the present development of the land because the road was already in place, it found that the task for the inspector was to ask whether the purpose of that obligation requiring the payment towards the highway continued to be useful. And it concluded that it was obviously useful for the local authority's perspective to continue to enforce the obligation in order to recover the expenses incurred by the council in building the road. That was a useful purpose because public money had been expended to facilitate the development, and it should be recovered where possible. So I think it's striking the way in which the courts, and these are all, I should say, first instance decisions, have interpreted the obligation to show a useful purpose. It doesn't seem to me obvious that, or self-evident, that the courts would have gone down this route and interpreted it in this very, very broad way. But that is what the cases show, and what that does is, I think, reinforce the point that the burden on developers is a high one, and that the discretion and all the cards really lie with the local authority. I set out on the next slide the application process, the form that the application has to take, the various notification and publicity obligations, and the determination period in which that needs to happen. So if you need an answer quickly and you don't get one in the usual way, there's a right of appeal against non-determination, unless, of course, you're prepared to negotiate a longer period for determination with the local authority. I did mention at the start that in respect of the modification of affordable housing requirements, there is a blueprint for what the government might do. It hasn't done so as yet in the form of Section 106BA. Now, this was a statutory provision which was introduced at the time of the last recession. It's no longer in force since it's no longer been enforced since April 2016. But as I said, I think it does provide a potential precedent for what the government might do. And what those measures did was effectively force local authorities to renegotiate Section 106 agreements, particularly in the context of affordable housing requirements. And if I might say so, in that context, they certainly shifted or began to level the playing field in that negotiation by putting the onus on local authorities to renegotiate and not simply wait out the 5-year period and turn a blind eye to those applications. What it did at the time was give developers the opportunity to appeal to PINS if they weren't satisfied with the outcome of those negotiations, or if there was no determination. The onus remained and would remain, if this were reintroduced, on developers to show that as a result of the affordable housing requirements in the Section 106, that development would no longer be economically viable. So in terms of the robustness and thoroughness of an application, in the same way as if one were in the position of having to show that an obligation no longer served a useful purpose, it would be important for a developer to substantiate that position with clear evidence, and in the context of viability, a fresh viability assessment, which would probably best be subject to independent scrutiny to show that unless the requirements in Section 106 can be modified to make the scheme viable, the scheme wouldn't be able to proceed. It's that sort of thorough evidence that one would be expected to present in the context of seeking planning consent in the first place, which would be required before one would be able to justify modification or even total discharge of the affordable housing requirements within a planning obligation. But that, as I said, hasn't been brought into force yet. There are, as Planning Magazine and other publications seem to be reporting, lobbying efforts taking place, and whether what's being lobbied for is something similar or the same as Section 106 BA seems to be the most likely scenario. But in terms of tips for developers, bringing all of this together, a clear awareness of the statutory framework is going to be very, very important. Be flexible, be pragmatic. Obviously, we all want to avoid scheme stalling, and there will be real pressing cash flow issues. And I think being in close contact with the local planning authority, being in dialogue with them, seeing if modifications can be agreed and achieved by agreement is going to be important. But where the formal application process is being followed, because that's what's required, then rather than I suppose approaching a local authority with a shopping list of, well, we would like, the vast majority of our obligations discharged and asking for the world, that sort of approach isn't going to work. Because local authority will have its own incentives to see and achieve those obligations, but also because it's unlikely to meet the statutory test. It's unlikely that you're going to be able to show that virtually the entirety of a planning agreement no longer serves a useful purpose. Much better, as I said, to enter into early dialogue with the local authority and be focused and specific in terms of the modification sought. I'd have thought modification rather than total discharge of obligation, unless it really does continue to serve no useful purpose, is likely to achieve greater success and the outcome that you want, rather than asking for the world. And as I said before, that application will need to be accompanied by robust evidence, well prepared, much in the same way as if you were making an application in the first instance. Fourth bullet, ascertain what scope there is for compromise, because the picture is not uniform right across the country. Some local planning authorities have taken a proactive approach and indicated their openness to being flexible. I give the example there of Manchester City Council, which has already announced that it will be delaying the collection of Section 106 contributions to completion in order to ease the immediate pressures on developers. So being aware of the local context, and finally avoid opportunism, because it simply won't work. Local authorities will be aware of the discretion that they have, and if an approach looks opportunistic, it's likely to be met with stony refusal. Better to be pragmatic, cooperative, and focused with well-evidenced requests for the modifications that you're seeking. And with that, I will hand over back over to Douglas.
Thank you very much. Thank you. Thank you very much indeed, Sarah. Before I begin with the residual points on planning obligations, could I just make one comment arising from Sarah's presentation? For my part, I have very serious doubts about the correctness of the approach in the Mansfield case, to the effect that a useful purpose does not need to be a planning purpose in Section 106A. The Section 106 obligations are instruments of planning practice, and to suggest that in terms of the powers to modify or discharge of 106, the residual purpose doesn't need to be a planning purpose is, in my view, seriously doubtful. That said, the case law that Sarah has referred to does demonstrate that the courts have taken a very relaxed approach generally to residual purposes, which would justify a refusal of an application under Section 106A. It is, however, notable that none of those cases have derived from the Court of Appeal. And I think it remains to be seen the extent to which the Court of Appeal would uphold, as a generality, the very broad approach that the High Court has taken to residual purposes under Section 106A, and in particular, whether it is right that those purposes do not need to be grounded in planning purposes. So watch this space, because an opportunity for the Court of Appeal to review those authorities will surely come. Now, that point aside, I turn to the topics that are on my slides. And the first is the enforcement of planning obligations. Now, as I'm sure many of you are aware, the principal authority now on the process and approach to enforcement is the decision of the Court of Appeal in Ali and Newham. And in that case, the Court of Appeal reviewed the approach that should be taken to applications for injunctions to enforce planning obligations. And an injunction is the prescribed statutory remedy for enforcement of breaches of planning obligations. That's provided in Section 106.5. For the more technically minded amongst those who are participating in this webinar, there is also the opportunity for specific performance against the original covenantor and the contract, but essentially in practice that comes down to the same thing, a mandatory order by the court to either do something or not do something. Now, the approach that the Court of Appeal took in Ali was a strict one, and the takeout of the Court of Appeal's decision is that where there has been a breach of a planning obligation, an injunction will normally follow as a matter of course. And the Court of Appeal approached injunctions under Section 106 essentially on normal contractual principles. That is, a court will generally hold a party to the obligation that it has entered into. And in particular, and importantly, the Court of Appeal expressly rejected applying the same broad discretion that the court exercises in respect of planning injunctions under Section 187B, where the court looks at the broad planning merits of the relief that a local planning authority is seeking. The court said, no, that is not the approach to Section 106. A stricter approach is required, and an injunction will usually only be withheld on normal equitable principles. That is, where the local planning authority has been guilty of unreasonable delay, or there's been some element of unconscionable behaviour that would justify withholding relief. And the court expressly rejected the submission made for the appellants in that case, that if it could be demonstrated in evidence to the court that the Section 106 obligation achieves no planning purpose, and that the planning merits generally don't support relief being granted, that should be a basis for withholding the injunction. Not so, says the Court of Appeal. It is not the role of the court to enter into consideration of the ongoing planning merits of the obligation sought to be enforced. So a very different approach there taken to Section 106 to normal planning injunctions where there's been a breach of planning control. Also, and perhaps importantly, the Court of Appeal found that where there's an outstanding planning application or appeal, which would have the effect, if allowed or granted and allowed, to make the 106 defunct, the Court of Appeal said that that was usually irrelevant to whether an injunction should be granted or withheld, albeit the court did indicate that on an exceptional basis, if there was a planning application or appeal that was pending, that could be a basis to suspend the injunction, not to withhold it, but to suspend it until the outcome of that appeal was known, but that discretion should be exercised sparingly. And by way of example, Ali was to do with an unlawful mosque that was taking place on an important development site in Newham. There was a Section 106 obligation that effectively required that use to cease and the buildings to be removed. There was a breach, but there was a planning appeal then before the Secretary of State following actually, it was a recovered appeal actually, made by the mosque following refusal of planning permission by Newham. The appeal was to be heard at an inquiry about 6 weeks after the Court of Appeal hearing. The mosque was long established. It had a very substantial congregation, and the undisputed evidence was that that use would have to cease and there would be nowhere for it to relocate if the injunction took effect immediately. So those circumstances the Court of Appeal found were exceptional and were a basis for suspending the injunction in that case. The question I pose at bullet point 3 on this slide is whether an outstanding application under section 106A, which effectively would either discharge or modify a planning obligation, would itself be a basis for withholding or suspending an injunction. I certainly doubt, on the basis of the Court of Appeal's approach, that would be a basis for withholding an injunction, but certainly there would be an argument that suspending an injunction may, just may, be sufficient to provide the exceptional circumstances leading to a non-immediate order in that kind of case. So essentially, the approach seems to be that where there is a breach, an injunction will follow. So it would be most unwise for a party who is bound by a section 106 obligation, whether it be the original covenant or a successor, to willingly or knowingly generate a breach with the expectation that in some way the court would come to its rescue. Because the current case law at Court of Appeal level suggests that a court is unlikely to be sympathetic, save in the most exceptional circumstances, to withholding enforcement if sought by the local planning authority. That said, of course, a local planning authority can resolve not to take immediate enforcement action, to give time for compliance, and that certainly seems to be an approach that accords with the spirit as to what the government is indicating in these times. But a local planning authority, if it were to do so, is likely to insist on some formal variation to the agreement to give more time, as opposed to simply letting enforcement proceedings lie in abeyance because of the dangers of delay and the court thereby withholding relief. So as far as the government's approach is concerned, I'm sure many of you will be familiar with the guidance issued on the 13th of May. The government recognised there is greater flexibility in terms of the administration of the Section 106 processes compared to CIL, which we'll turn to in a moment. The objective in terms of applying flexibility is to remove barriers to development and avoid site stalling, effectively to address cash flow issues. And the express advice of the government in light of the COVID-19 outbreak is to encourage deferment of compliance with the terms of Section 106 and take a pragmatic and proportionate approach to enforcement. And Sarah's already referred to the example being set by Manchester City Council, which is deferring contributions to the completion of development where otherwise they would crystallise before. If there is to be deferment, I would certainly suggest it's appropriate for that to be recorded in a deed of variation or a supplementary deed, rather than letting matters simply lie on a non-confirmed basis. Local authorities should be wary, and indeed developers and landowners should be wary of effectively extinguishing covenants in totality by reason of simply delaying deferment, because if a Section 106 was entered into for sound planning reasons, and finally, slide, if a developer is having considerable difficulties in compliance with a Section 106 obligation, it of course is entitled to approach the local authority and ask it to agree either deferment to enforcement or indeed to agree a variation of the Section 106 under its power to do so by agreement rather than through the formal processes. Following on from the Bachelor case that Sarah referred to, I would suggest that if a developer who was bound by a 106 was in that position and went to the local planning authority, the local planning authority must consider exercising that discretion. It simply can't just shut the door in the developer or landowner's face, because that would be effectively not exercising or even considering exercising a discretion at all, just in the way that in Bachelor, the High Court confirmed that if a party to a 106 approaches a local authority to agree to modification of a Section 106, the local authority cannot simply say, we are not even going to consider that request. So if a landowner or developer is confronted with effectively stonewalling by a local authority, then there is the possibility, it seems to me, of drawing attention to the prospect of legal action if they simply refuse to entertain out of hand any request for a variation, or indeed a request for delay in enforcement. Just one or two other matters on 106. The importance of section 106 is very familiar to all. It provides for covenants to be enforceable against successors in title without the necessary necessity for local authorities to have benefited land, and provides for positive covenants to be enforceable against successors in title, neither of which would apply to a restricted covenant under normal common law principles. It is important to check in all cases, and certainly where there may be difficulties in complying with the section 106, as to whether the 106 is legally compliant in the first place. Firstly, does the 106, in the form it was entered into, meet the requirements for a section 106 prescribed by section 106 subsection 9? Essentially, is it a deed? Is it entered into having identified who the enforcing authority is? Does it prescribe that it's section 106? Now, those are important and have elevated importance following the decision of the Chancery Division in Southampton and Halliard, where the High Court held that if one of the requirements or the formalities in section 106.9 is not met, then the agreement, albeit existing in contract, will not have the statutory effect of section 106, in particular in terms of its engagement with successors in title. And secondly, do the covenants fall within section 106 subsection 1? Section 106 subsection 1 is a closed list of what can and cannot therefore be included within section 106, so as to have a statutory effect. And the Kadari case, which I'm sure many of you will be familiar with, in which the Court of Appeal held that restricting the ability of future occupants to seek parking permits does not fall within section 106, is an example of the importance of scrutinising the obligation to see whether in fact it falls within the terms of the section. So I turn then to CIL. It, I think, is generally recognised that the flexibility for collecting and charging authorities in respect of the accrual and recovery of CIL liability is limited, very considerably limited, and much more so than section 106. The CIL regulations are expressed in largely mandatory terms, as is entirely befitting of what effectively is taxation legislation, with little discretion provided. And I set up there an example. Regulation 69, a collecting authority must, not may, must serve a demand notice. And the government have recognised this lack of flexibility and have indicated an intention to introduce amending regulations to provide a greater degree of flexibility. As matters stood, certainly yesterday, there were no draft regulations laid before Parliament. They would have to be laid before Parliament, and a period of at least 6 weeks would have to expire before they took effect. So it's some time off before there will be any express flexibility of the nature that the government have indicated. And what that flexibility is to comprise is wholly unclear at the moment, but it seems to be suggested that that flexibility will be directed in particular, if not wholly, to SMEs rather than larger developers. In the interim, the government has advised that the collecting authorities and charging authorities exercise flexibility, but as I've indicated, that the scope of that is singularly limited so far as the regulations are concerned. And there are essentially 5 elements where flexibility may give rise to a basis for assisting the development industry. The first is the introduction or the amendment of instalments policies. And the government have expressly advised that a review of instalments policies is appropriate to reflect constraints on the development industries. Instalment policies are provided for by Regulation 69B. There is a broad discretion as to whether a collecting authority should adopt or indeed amend an instalments policy. They can amend the policy without consultation unless the statement of community involvement provides otherwise, and indeed statements of community involvement can be amended without consultation. So there's no particular procedural obstacle to a rapid and immediate amendment. The policy and the amendment can take effect on the day after it is published. Publication requires web-based publication and also physical deposit. Now, physical deposit of any document provided for under the planning legislation is difficult, if not impossible, in light of the lockdown. For my part, I think it is most unlikely that the inability to physically deposit an amended or indeed a new instalments policy, or indeed any other kind of document, such as a emerging local plan or whatever, would be found by the court in these extraordinary circumstances as a basis for quashing the effect of the instalments policy, new or amended, or any other document. So do not get hung up by the difficulties of physical deposit. As I indicated, the discretion is a very broad one in terms of what a collecting authority can provide for in its instalments policy. It can include the number of instalments, the amount or proportion payable, dates of payment, and importantly, the minimum liability before the policy is engaged, because most instalments policies have a floor, effectively a bottom line below which instalments policy is not able to be relied upon. And that, a change to that may well be an approach that would be appropriate for most local authorities, particularly to deal with the difficulties being encountered by small and medium-sized developers. I note that the ministerial guidance suggests that any instalments policy or amended policy can only apply in respect of developments commenced after it is published. The indication is that an amendment to an instalment policy cannot be retrospective. Again, for my part, I don't consider the legislation is quite as clear-cut as that. There is certainly no limitation as to the effect of an instalments policy and whether it can have a retrospective effect in Regulation 69A. It may be that the effect of Regulation 70, which provides for payment, which requires payment in accordance with that instalment policy, that means the instalment policy at point of commencement, if that policy means the policy in the form in which it existed at commencement. Now that is arguable, but in my view, it is not clear-cut. And it seems to me there is certainly scope for it to be argued that where an instalments policy is amended, that instalments policy can have a retrospective effect in terms of applying to development that is already engaging the instalments policy following its commencement. And it's certainly important to bear that in mind in terms of any representations that you might make to a collecting authority, or if you are a collecting authority, how you express or apply any amended instalments policy. Regulation 69, demand notices, provides that the amount payable pursuant to instalments must be set out in a demand notice. But of course, a demand notice may be revised at any time. So there's certainly scope, if there is an amendment to a instalments policy that has a retrospective effect in terms of development already commenced, for that to be reflected in a modified demand notice. I note that one collecting authority has not, it seems, amended its instalments policy, but has served revised demand notices across the board with a 3-month deferment period, where a developer can prove they meet what is prescribed to be the small or medium-sized criteria. Pragmatic, yes. Flexible, yes. Helpful, certainly. But query whether there's power to do that within the context of the legislation. It seems to me that if there is to be a change in an instalments policy, that ought to be introduced by an amendment to an instalments policy. And there is certainly nothing that seems to me to support an approach, however laudable it may be in its objective, to have effectively a portmanteau revision to demand notices to introduce through that mechanism a 3-month deferment period. So certainly something to think about in terms of whether that kind of approach is the right one legally and compliant with the legislation. And I note finally on this topic that there are limitations to instalments policies. It can only be applied where a person has assumed liability and served a commencement notice. Doesn't apply where the collecting authority is determined the deemed commencement date. And if you miss an instalment, you have had it. Payment then accrues in full. So essentially, instalments policies are only available to developers who effectively do what they are required and continue to do what they're required under the legislation. It's effectively available to the good boys and girls only. Secondly, exceptional circumstances relief. Exceptional circumstances relief provided for by Regulation 57, but in my experience, a very rare beast. And there are only few collecting authorities, charging authorities, I should say, who've introduced it. It is an interesting provision in terms of the opportunity that it provides in giving flexibility in these particular circumstances. There are practical limitations, and I mean limitations, mandatory requirements within the legislation. That is, that the claim must be made and determined before the commencement of development. It must be accompanied by an independent economic viability assessment and an explanation as to why the payment will have an unacceptable impact on the viability of the development. That independent person carrying out the assessment has to be approved by the local authority, and it can only be made, a claim can only be made where Section 106 is in place. It isn't available where social housing relief is granted or where charitable relief is granted, and that is likely to be a significant practical impediment to the availability of exceptional circumstances relief for residential development, and it will be lost if the land is disposed of before commencement. And finally, but not no least importantly, if exceptional circumstances relief is granted, development must commence within 12 months. So there are a lot of checks and balances in terms of exceptional circumstances relief, even when it's made available. And as I said, I don't see that there's a great deal of scope for it to be engaged so far as social housing relief is concerned, where that's made available, which will be the case for many residential developments. As far as the local authority's discretion is concerned, if an application is made in accordance with the requirements, the local authority can only entertain the application if it's expressly made exceptional circumstances relief available in this area. There is, as I said, a Section 106 in place. The authority is satisfied with the evidence in terms of economic effects. It would not amount to state aid. And then finally, that the authority is satisfied that there are exceptional circumstances which justify the grant of relief and it is expedient to do so. Now that latter point is an interesting one because it seems to suggest that even if the economic case is made out to the satisfaction of the authority, there would still need to be exceptional circumstances. The legislation does not prescribe what those circumstances are. It would seem to me that they would cover situations where a development, for example, is considered to be manifestly in the public interest in terms of what it delivers. So housing development, if it fell within the parameters of the relief, would be one such example. Some other kind of community development would be another. So that may be the kind of exceptional circumstances that would justify relief and getting over that final and difficult evidential hurdle. No appeal process if relief is refused. The only route is JR. And from a practical perspective, exceptional circumstances relief is a hungry process in terms of resources for a collecting authority. And secondly, if a landowner or developer is going to go down that route, it's an open book approach. There will have to be full transparency of the economics of development and its viability provided to the independent assessor and then to the local authority. And that for many may be a disadvantage of going down that route. I then turn briefly, as far as the time allows, to phased development. Again, as you are all, I'm sure, aware, that where development is expressly phased, then CIL is payable on a phased basis, with each phase being a different chargeable development. And that, of course, can have significant beneficial effects in terms of cash flow, particularly if, by way of example, phase one simply is infrastructure works, where CIL liability may be zero. And that kind of approach would allow development to commence, thereby protecting the planning permission without incurring liability. However, and importantly, a phased planning permission must be, as the definition requires, a permission which expressly provides for the development to be carried out in phases. And that is a point that has drawn the interest of the courts. The Oval Estates versus Bath North East Somerset decision in the High Court is informative. That was an outline planning permission with no phasing condition, a reserve matters approval with a phasing plan approved, and a Section 96A application post commencement of the chargeable development, which introduced the phasing plan into the list of approved drawings on the outline planning permission. Mr. Justice Swift held that the planning permission was not a phased planning permission and that the Section 96A non-material amendment did not rescue the position so far as the developer is concerned, and it did not change the CIL liability that accrued on commencement. I have to say that I have some difficulty with that latter point because Section 96A, unlike Section 73, modifies the original planning permission, and if that is the operative effect of Section 96A, it's difficult to see why thereafter, following that change, the whole development pursuant to that permission should not be a phased permission. But nonetheless, the approach that the court took in that case effectively is binding upon collecting authorities now. So far as phasing is concerned, happy days if the permission is phased at the outset, and it is certainly safer to get an express phasing condition attached to the original permission. If you don't, and are seeking then to take advantage of phasing for CIL purposes, danger if reliance is only on Section 96A following the Oval Estates. However, it is possible that the same outcome can be achieved by going down the Section 73 route and thereby taking advantage of Regulation 9, which provides effectively for a Section 73 consent to overtake the original planning consent, including the effect of the phasing condition. Final 2 points: relief from late payment surcharge. Late payment surcharge, Regulation 85 provides that the collecting authority may impose a late payment surcharge. One of the rare exceptions within the CIL regulations of may rather than must being used. Plainly, there is a discretion, and plainly, a collecting authority can waive the late payment surcharge if it thinks that there are good reasons, including reasons relating to the pressure on development, to do so. Some commentators have referred to potential for reversing surcharge liability or even repayment. Nothing in the legislation that refers to that, but I can certainly see that there is an arguable case, perhaps even strongly arguable, that if there is a discretion to impose a late payment surcharge, there must be a discretion to reverse that surcharge payment. And therefore, it seems arguable that there is a power to do so implied. As far as late payment interest is concerned, there is no power to waive late payment interest. It is a must, not a may, no discretion, and it accrues. And it is notable that the late payment interest provisions are one of the regulations that the government have indicated they are expressly considering amending within the CIL regulations to provide flexibility. Lastly, so far as enforcement is concerned, there are a whole suite of powers available for enforcement if CIL is not paid. They include the power to serve stop notices and the power to apply for liability orders, and following liability orders, a power to seek restraint, for committal to prison, and for charging orders. Note that all of those powers are expressed in terms of may, not must, and there is plainly down the route of applying for a liability order to the justices. The court has virtually no discretion in terms of withholding a liability order if it's satisfied that an amount has not been paid. So a liability order will usually follow from an application being made. However, the court has much greater discretion in terms of withholding a order for committal or charging orders where broad issues relating to ability to pay come into play. However, I would observe that it is unlikely that even if a local authority, a collecting authority, were minded to give some time before it took enforcement action, that it could lawfully use its discretion to delay enforcement action so as to effectively waive liability. That would not be consistent with the whole purpose of the legislation. So effectively prevailing upon a collecting authority to delay enforcement is an opportunity that is there, prevailing upon a local authority to delay enforcement so effectively not to perform its functions ultimately as collecting authority is, in my view, highly dubious. So that completes the slides. I'm going to stop there and invite Sarah to come back online. I think we had some questions, Sarah. Did you have a chance to have a look at those?
I think most of them relate to your presentation on CIL, Douglas. I'm not trying to pass the buck,
okay.
But they seem to be focused on CIL.
Let me have a quick look at those then. We'll just take a few more minutes to go through those if people want to check them out if they're interested. I see David's question first. If new flexibility regulations are brought in, is there not a danger that if the council takes a flexible approach on CIL, that the payments are not paid on commencement of development in order to help developers with cash flow, that a developer might fold the company that was still liable, who would liability then pass on to? Well, that is a very good question, David. It seems to me that that is a very considerable risk. I mean, it seems to me that if that were to happen, then there are provisions within the regulations that provide for CIL liability effectively to cascade down from a developer potentially onto landowners. So that may be where liability ultimately lies. But I certainly agree that if there is flexibility and if there is effectively the waiver waiver of timely compliance in accordance with the regulations of payments, that there is then a risk that default occurs, and if default then occurs, the ability to recover may become more difficult for collecting authority. I'll have a think about that further, David, and if I have any further points, I'll respond to you directly on those. Second question from Tim Baines: if developments need to be changed to reduce costs by way of a Section 73, is it now clear that CIL will only apply to the additional floor space subject to the Section 73 and not calculated on the basis of the floor space of the whole development? Well, that is a interesting point, because Sarah and I, a year or so ago, were involved in a case that was to do with that. And that case arose out of the mess that was Section 119A, as I recall at the time, which had all sorts of provisions relating to indexation and how it applied to Section 73. But Tim, my understanding is, and I haven't looked at this for some time, but my understanding is that the 2019, I think there were amendments to the CIL regulations, did operate to regulate the Section 73 process, so that any uplifted CIL and indexation applying to it only applied to the increased floor space. Again, that's my recollection. I haven't looked at it for some time, but if I have any further thoughts on that, again, I'll come back to you directly. And then from Jenny Baker: if a collecting authority agrees variations to the timing of CIL payments informally, are there state aid implications? And is there a risk of challenge by a vociferous objector? And if so, what might the relief granted by the court be? So far as state aid is concerned, I mean, that is very much a sort of hornet's nest in terms of what the implications are. I can certainly see that there may be scope, I don't put it any higher than that, scope to argue that effectively an informal arrangement with an individual developer that isn't available across the board may have some state aid implications. But even if it did, I mean, there are a whole series of issues that arise in relation to state aid, in terms of whether the de minimis threshold, for example, is reached, and that is a substantial amount of money, which doesn't give rise to actionable state aid in circumstances where that relief is granted. But I can certainly say at this stage that simply ad hoc type of arrangements, certainly if they involve any substantial relaxation to the liability for CIL, or indeed, I suppose, to an extent, the time period for payment, that there would need, the state aid implications of that may need to be considered. But as I said, there are a whole series of issues that are available in terms of state aid arguments that may have the effect of avoiding, even if there is in principle some argument for state aid that being actionable. As far as challenge is concerned, I mean, if a local authority were to, or collecting authority were to relax its usual enforcement processes to give time, then there's a very broad discretion, as I've indicated, to do that, and the only basis for challenge would be by way of judicial review, and given the breadth of discretion, I think that is unlikely, it seems to me, that a court would readily find that there has been an unlawful exercise of what is a broad discretion to respond to the particular circumstances of an individual developer. So that, I think, deals with the three questions. We're now beyond 11 o'clock. So thank you very much for joining us. If anybody has any further questions, then feel free to contact Sarah and I offline, and we'll do our best to help you with them. So I wish you all a very good morning, and thank you for joining us this morning.